to another informative segment of Live with Mitch from the law firm of Proner and Proner. I'm your host, Mel McCoyup, and we sit down with the expert himself, Mr. Mitch Proner, a personal injury attorney with over 30 years of experience, here to answer your questions or any interesting topics that you might find useful in the personal injury world. How are you doing, Mitch?
I'm doing great. I'm doing great. Let's let it rip with the topic. Okay, so yes, you can have workers' comp and a third party claim. So typically, you have to understand the requirements to bring each. First of all, for both workers' comp and third party personal injury lawsuits, the one common denominator is typically somebody got injured.
Okay.
Okay, let's start with workers' comp. For a workers' comp claim, you need to show that you were incapacitated. You couldn't work for at least a week. That's typically the threshold to have a workers' comp claim. Number two, it had to occur at work. If
Okay.
you got injured at work, regardless of fault, it doesn't matter who's at fault. If you got injured at work and you've suffered a debilitating injury, you're entitled to compensation under workers' comp. So if I take my glasses and I'm going to put them on and I actually poke my eye out and I'm left with one eye, even though it's my fault because I can't put on a simple pair of glasses, I'm entitled to workers' comp because I did it while I was working.
Right.
If I did it home, not workers' comp. If I did it in my car on the way to work, not workers' comp.
Mhm.
So sometimes you see a woman putting on makeup in the rearview mirror. If she puts the lipstick in her eye and she says, "Oh, but I was just getting ready for work," not a case.
Okay.
All right. Suppose you're leaving your car and you're in the parking lot and you're on your way to work. Typically not a case. But if it's in the middle of your work day and you're going on sales calls and that's part of the work is using the car and going around, then that might be part of the work and it might be a case. So that could be facts determinative. Okay. For workers' comp, you need to have an injury at work. Doesn't matter who's at fault.
Okay.
There are other requirements. Within 30 days, you have to report the incident to your employer. If you have an incident with injuries, you got to let your employer know there was an incident. You can't just like forget about it, get fired, and then 2 months later call up a lawyer and say, "Oh yeah, by the way, I got hurt before I got fired."
Right.
Did you ever report it to your boss? No. But I went to a doctor. Doesn't matter. You proved your injury, but you have to report it to your employer within 30 days. That's a rule. Okay. Once you comply with those rules, the employer has obligations. They have to report it to a carrier. The carrier has to notify of your rights. And then you're entitled to payments for the entire time you're disabled for 2/3 of your lost earnings in New York, multiplied by your percent incapacity. So if you're completely disabled, you get 100% times 2/3.
Mhm.
If you're 50% disabled, it's 50% of 2/3 of your gross earnings before taxes, before FICA, before any deductions. What's your gross pay? 2/3 of that goes to you, multiplied by your disability. You also get all your medical bills paid. That's for workers' comp. Now, you might be entitled to more money aside from what workers' comp pays. For example, if it's a motor vehicle accident. In New York, there's a no-fault law. No fault on your own car insurance pays you 80% of your lost earnings up to $2,000 a month.
Wow.
Now, that 80% of your lost earnings is more than 2/3. 2/3 is approximately 66.67%. 80%
Mhm.
is more than 66.67%. So you might get two checks,
Oh.
one from workers' comp and one from your own no fault insurance. But no fault might deduct $170 a week that you get from disability if your employer provides that. So it's complicated. But starting with just workers' comp, loss of earnings to date, to the present, paid every 2 weeks, every 15 days, and your medical bill is paid.
Oh, wow.
Lawsuits typically pay much more. A workers' comp claim is not a lawsuit because it's an insurance claim. You're claiming from your employer's insurance. Every employer is required to have insurance for their employees, and workers' comp is that insurance benefit. So
Okay.
just like your employee does his hours, does his work, the employer has to pay for insurance in case that employee gets hurt. Now, does every employer do that? No. A lot of times people say, I'll pay you off the books.
Oh.
Typically, when you're paid off the books, you might not get those benefits because your employer is doing something shady.
Okay.
Have we got workers' comp claims in my office for people that were paid off the books? Yes. Have we got them money? Yes. Typically, they get hurt at work, and then a judge determines their wages.
Mm.
And if they don't have insurance benefits from their employer, there might be other companies that have the insurance that will be ruled they have to cover them. For example, if somebody's working for a subcontractor, the GC might have to provide workers' comp insurance. Additionally, if there's no workers' comp insurance, a state insurance fund might provide the benefits, and then they could go against the employer individually for reimbursement.
Okay.
Now, with a lawsuit, typically you're entitled to, if you can bring a lawsuit, much more money, because in a lawsuit, you're also entitled to future medical benefits, future lost earnings, not just to date, and more importantly, money for pain and suffering, including the loss of quality of life.
Right.
So, pain and suffering is usually the largest part of the award for personal injuries. You don't get pain and suffering in a workers' comp claim. But to get that money for pain and suffering, the much larger award, you need to show fault.
Okay.
And the fault can't be your own fault. Like my example, putting glasses in my eyes, losing my eye. That's fine for workers' comp. But who's at fault for my injury putting on my glasses? Well, the glasses manufacturer is a defective product. It should have a tennis ball on the end. No. Nobody's wearing glasses with tennis balls on the end. It's my fault. There's no case. Now, sometimes products do have safeguards that should be there, and you can bring a products liability accident. So even the accident is your fault, there might be a reason to expect that there should be a better product. For example, airbags that deploy, seat belts, crash-worthy cars, garage doors that have an alarm when they go down, trucks that make audible signals when they back up, the removal of products like asbestos and the Dalcon shield that maimed women's reproductive organs. They were all changes that were made because of successful lawsuits and lawyers like me. So there are products cases. So oftentimes an attorney can find fault even where the individual might not realize there's a potential action. So it's always a good idea to contact a competent and skilled attorney. How do you know if your attorney's competent and skilled? Well, one thing is you want to make sure somebody focuses primarily in personal injury and trial law. If somebody says I do real estate closings and they're your business lawyer and they do elderly law, they help you write a will, so you got hurt, you figure, oh, let me call my lawyer first. That lawyer might take your case, say, oh, I could do this. I'll send them all the insurance company medical bills and I'll try and settle it. That's not the most skilled attorneys in my profession.
Mm-hmm.
I do nothing but accident claims and I try them, and I've lectured around the country on how to handle motorcycle accident cases. I was elected president of the New York State Academy of Trial Lawyers. I have a reputation for doing only this work. And it's challenging doing only this work. I don't think I could be successful if I tried to be a trial lawyer and do closings.
Right.
And do divorce. And I'll find people if they call me up, friends, family, even clients. They call me up, I got another issue. Can you help me with it? Sure, let me get you somebody who does that. So that's the first thing, is try and do some research in terms of who you're talking to. But a lot of times a skilled attorney can find a pocket to pay for the damage that you might not know existed. Okay, now you have to prove fault. That fault can't be your own. It also can't be your employer's or a coworker, because that's covered under workers' comp. So if you're working in a yard and one of your coworkers drives a forklift into you, that might just be a workers' comp claim. But if you're exposed to a gravity-related risk, for example, you fall into an uncovered hole, or you fall off a ladder that's not secured properly, or if you should have had scaffolding that wasn't provided, the owner of the premises may be liable for those injuries. So you could bring a claim against that owner, even though they weren't even there. They had nothing to do with putting up the scaffold or the ladder. They just hired your company. But if it's a single family residence, they could get an exemption from that law and they don't have to pay. So often those are facts determinative claims as well. But typically the third party action, which is the claim against the wrongdoer, is worth more than the workers' comp. Why is it called third party? The reason it's called a third party action is because in a contract, you have two parties to the contract, right? A contract's an agreement. So
Okay.
it's an agreement between who? Somebody or some company and somebody else or some company else. Two parties. And typically a contract identifies the parties at the top. Workers' comp, because it's based on an insurance agreement, it's a contractual agreement, it's a first party benefit.